Good morning, all. As Ted did in his welcome this morning, I want to wish you all a warm welcome and thank you for attending. My name's Mark Crane. I'm a partner in the advocacy group here in Toronto. I focus, amongst other areas, in infrastructure and construction disputes, and I lead our firm's national arbitration group. And for the next 10 minutes or so, I'm going to talk to you about adjudication, which Ted's given you some context for. And on this first slide, I just put up some of the questions and responses that I hope I'll touch on in this time. So what is adjudication? What are the policy reasons behind it? How does it actually work? What are the mechanics of it? Who are the adjudicators and how do they get to be adjudicators? And is this regime gone on elsewhere? And is there something that we can reflect on from what's gone on in other jurisdictions and what their experience has been? So let me start off by what is adjudication. It's intended to be a dispute resolution regime, quick and rough justice. It's intended to settle disputes from a proper invoice. You listened to Ted a few minutes ago talk about the importance of a proper invoice. That's been submitted by a party to a contract that is subject to the Act, and it generally will be a dispute over an invoice or the valuation of services, and we'll come to the specifics within the Act that sets it out. But assuming a proper invoice over a payment cycle has been submitted and there's a dispute, the intention is that you can try and have this dispute started and settled within about 30 days. And so that's the intention. It will be mandatory, as will prompt payment be, and so parties to a contract cannot contract out of adjudication. It's intended to be there. It doesn't limit other dispute resolution processes or regimes that the parties may enter into, so you can still commence an action in the court if you want, or you can still arbitrate, but adjudication is not something that the parties can contract out of, so it will be mandatory. And what are some of the policy reasons behind it? When you looked at the authors of the report who made the recommendation for adjudication, the intention, as you can see from the slide, is just to keep the money moving down the construction pyramid. It's intended to, with a view to keeping the project rolling forward and getting projects completed, and money out of the hands of owners and contractors and into the hands of contractors and subcontractors. Adjudication will commence on October 1st, 2019, and there's still some regulations that will need to be borne out that will provide some meat on the bones of the process, but we have a pretty good perspective of how it will proceed and how it's intended to proceed. Let me just go keep it. I like this slide because I think it just gives a context for the process. So who are the adjudicators? And I'll come to the mechanics of the process in a few minutes, but the adjudicators will be individuals who will be appointed by an organization called the Authorized Nominating Authority. And the ANA will oversee the appointment of adjudicators, the training of them. It will maintain a roster of who the adjudicators will be, and it will appoint adjudicators if need be, if the parties can't come to a process where they can mutually appoint an agreeable adjudicator that is not conflicted out. And who is it expected that the adjudicators will be? What type of backgrounds that they'll be, will they have? And some of them may be lawyers, but legal training won't be a prerequisite to becoming an adjudicator. And indeed, it may be not the norm as it will unfold. I think the expectation is that they'll have professional designations, so whether they'll be engineers or architects or quantity surveyors. Those are the type of people that will have the level of sophistication and experience to resolve disputes arising out of construction disputes over the process of a payment cycle. And let me just take you through some of the process to give you some context, and then I'll come back on some of the experiences that we've seen in other jurisdictions, including the United Kingdom. And so at a high level, a party will commence an adjudication if there is a dispute. And so who can start an adjudication? Anyone can. A contractor, an owner, a subcontractor, anyone who's a party to a contract that's involved in the construction or adding value to services of land in a construction setting. It will be commenced at a high level by a party delivering a notice of adjudication to their contracting party with whom they have the dispute. And within that, they'll identify, I've got a more detailed chart here that sets out the process. May be difficult for some people to see up on the screen, but it gives sort of the mechanics of the process. But ultimately, you'll give a notice of adjudication to the other party. The next main step in the process will be either that the parties will agree upon an adjudicator who's been qualified by the ANA, obviously. And if not, then there will be a dispute resolution regime where an adjudicator will be appointed. And within 5 days of the adjudicator being appointed, he or she is to be delivered the notice of adjudication, the address of the parties, the contract, and any documents that the moving party is intending to rely upon in the process. It's not yet borne out in the legislation, but indeed it will be in the regulations what the process will be for the responding party, but ultimately they'll be given an opportunity to respond in writing in terms of their response as it relates to the dispute. And then this is where you sort of cut to the chase. Within 30 days so you've got 5 days to deliver documents to the adjudicator. Thereafter, the adjudicator has 30 days to resolve the dispute, with a view that the resolution will be binding on the parties within 10 days. So that's, in a nutshell, the adjudication process. And you can see that in context to the traditional litigation regime that may otherwise would go on. It would be much quicker and provide an outcome as it relates to a payment dispute in a particular billing cycle. So here I've set out the type of dispute that, as set out in the legislation, of what can be referred to an adjudication. And as you can see, I mentioned the valuation of services, but it's got to be something under a contract. If I just pause there for a moment, because I think one of the important contexts here is what's gone on and what do parties think about this. And so we have the benefit of having spoken with some of our colleagues in the United Kingdom where adjudication has gone on there for approximately 20 years. So here in Ontario, and particularly maybe less so today, but in the last few years, parties, owners, contractors, but I think more so perhaps owners have been nervous about adjudication because there's an impression that they may be swamped with adjudications if there's going to be a dispute every month, that a party may be able to prepare their adjudication materials, dump them on the other party, the owner per se, and then the owner will have to turn around a record relatively quickly, and with a view that that may distract the parties from carrying on the actual business of the project. It may create time consequences, and it may transition the focus away from perhaps project management or carrying out the project to contract administration and to managing sort of death by a thousand swords. In the experience that we've heard back from our colleagues in the United Kingdom is that when adjudication started 20 years ago or thereabouts, the process was a bit of a wild west at the front end of it, and people didn't know what to expect. But as it got matured and people got experience with it, it's actually proven to be a useful dispute resolution regime. I think with the 30-day process, the focus on contract administration and having to turn around a record relatively quickly, I think that's quite true, but you are dealing with it on a payment cycle, and the documents will still be relatively fresh of mind, people's memories will be fresh of mind, and when you've got the push of a 30-day limit or an adjudicator is going to decide it one way or the other, it limits the ability of parties to posture or delay, which are tools that are sometimes used, as you know, in the litigation process. And so it cuts to the chase more quickly, unless there is a legitimate, reasonable dispute, one side versus the other, as to what occurred or what is owed, that as you go through the adjudication process, I think the parties, oftentimes in the United Kingdom, the adjudication is never actually heard because the matter gets resolved before so. And so for that reason, as the industry's matured in the United Kingdom, I think they've found it to be a a useful tool, and indeed with a view to keeping the money moving down the pyramid. So I'll go through some of the mechanics of the legislation. So I've touched on this briefly, but who can request an adjudication? Anyone. Anyone who's got a contract and who's got a dispute over an invoice as it relates to a construction dispute. And when can it be commenced? It can be commenced when there's over a proper invoice that hasn't been paid. And you've got to commence the adjudication prior to the completion of the contract. But other than that, you can commence it whenever you want, by anyone you want, but you've got to be a party to a contract, and it's got to be over a matter that can be adjudicated, and we've had a look at the list of what that is, but generally it's a valuation of services or an unpaid invoice is what you would anticipate. The process for the adjudication in terms of, you've got the 30-day window between when the adjudicator gets the materials and when a decision needs to be rendered. What happens in that interim is subject to some flexibility. The parties may be able to lay out in their contract a proposed process for the mechanics of how the adjudication will be heard, whether it'll be heard just in writing or whether there'll be a hearing, an oral hearing on the matter in addition to the evidence. So I think the parties can have a role in how the process is intended to unfold, and if not, it will be within the jurisdiction of the adjudicator to set that out. The adjudicator, as set out by the legislation, will have the discretion to probe and ask questions of himself or herself in order to satisfy themselves what the facts are and assist them in carrying out their mandate. So it can be inquisitorial in nature, which is unique from our court system, where we typically a judge who is normally not sitting in the seat of an inquisitor asking questions, but they're rather hearing and receiving evidence and then making conclusions based upon what was put before them. So I think there'll be some flexibility, all with the view to getting to the bottom of it quickly and having rough justice. And by rough justice, let me just plow through these. We'll come to the costs in a moment. By rough justice, it's a conclusion within 30 days. Payment is to be required 10 days thereafter. That doesn't limit a party who perhaps feels they've been wronged one way or the other from litigating the matter at the termination of the contract, but the payment, whatever is owed or not owed, needs to be paid within 10 days. If you want to come back at the end of the contract and have the decision reviewed or carry on with civil litigation either in contract or in tort, then you're entitled to do so. But as it relates to that dispute, it's binding and it's final on an interim basis with a view that you can come back and resolve it at the end of the day. But it's all with a view to keeping the process moving forward. I've got the screen up now for who bears the cost of an adjudication, but for a few examples, which I'll come to an example, it's intended that the parties will bear their own costs for the adjudication. And that too is, I think, with a view to taking out the David and Goliath factor of it all, and someone can't posture an adjudication with a view to trying to have someone eat their legal fees at the end of the day, to the extent they'll have legal fees. But so everyone's going in with their eyes open. If there's going to be an adjudication, you're going to carry your own costs. And in this process, you may be able to proceed without counsel. It may be just your technical experts that will deliver the evidence. It may be adjudicated by an engineer or an architect or a quantity surveyor, and all with a view to getting it done quickly. You'll see at 1317, there is a provision there where if it's found an adjudication was brought or the conduct has been frivolous or vexatious, then they do reserve their rights on costs, but you would anticipate that to be rare. We've spoken about whether an adjudicator's decision is binding, and I've set out here and you can see it at 1315. It's intended to be binding on the parties to the adjudication until a determination of the matter by a court or any determination of the matter by way of an arbitrator conducted under the Arbitration Act. So at the end of the day, you can still fight about it. It's anticipated, I think, or the spirit of the legislation is that you do so at the termination of the contract, to let the contract run its out, but there is still that discretion. Let's see what's coming up. Next slide sets out whether you can be exempt from the adjudication provisions. Once it comes into force, you will not be exempt. As I said, you cannot contract down to this, and you can see what it has to say on grandfathering. I think a couple of the points, the most important points that I wanted to make are some of the takeaways from adjudication, apart from the mechanics of the process. And as I look at adjudication, how is it going to impact your organization, if at all, and what should you start thinking about? And given what I've described, I think owners, contractors, and subcontractors will need to be prepared to turn around a record relatively quickly if they're going to be responding to an adjudication. And so that may put, and some organizations, I think, in my experience, are already there and do that very well, and some organizations could probably paper their files better, or have a better document maintenance system, so that they're a record system, so that they can pull the documents and slice and dice them in a particular manner relatively quickly. So I think that you should give some thought, owners and contractors, to contract administration. There may be an increased focus on contract administration with the view that you may need to respond quickly to matters over a payment cycle. It may impact how you paper the file. So I think there'll be an increased focus on that. There's obviously the authorized nominating authority is going to be, will need to populate a roster of adjudicators. So I think there's opportunities for lawyers perhaps, but more particularly I think probably engineers, architects, quantity surveyors who are interested in becoming involved in that industry as adjudicators. But I think it's the internalization that will go on that will parties, because owners may find that they do have a regular payment cycle dispute, and they're going to have to go through this every month on a particular project. So I think there needs to be a focus on a thought on what those impacts will be, if any, on your organization. So that's what I intended to cover as it relates to adjudication.